All right, let's go ahead and get started. So we've moved into now the extra remedies part of the class, right? We've done all of the obvious remedies. That is our three big ones, of which one is the super huge one, the expectation measure of remedies. And we've talked about some of the objective versus subjective problems of measuring what someone expects would have happened if the contract had been performed, given that in every single case for breach of contract, that contract has not been performed. And so we talked about the problem of uncracking that egg and where that's going to go. We then talked about some ways in which courts turned to their old friends, reliance and restitution, to resolve certain kinds of problems that they weren't able to do. For example, if damages are too speculative, we might turn to a reliance measure of damages for new business problems. If damages can't be recovered in breach of contract because the party that is suing for the damages, in fact, was the one that breached the contract after performing part of it, then we might use something like restitution to give that breaching party back the value of what they did. But we also then ran into troubles with that one. And so we had these various caps, a cap on reliance damage at expectation, a cap on restitution damages at expectation, because of what we saw in the most recent Palmer case, in which the court did the fair market value, quote unquote, of the work that had been done, came up with a huge number, tacked that on top of what had already been paid, and you would have realized that the breaching party was hitting the non-breaching party up for way more money than that non-breaching party would have had to pay if the contract had been fulfilled. And so we ran into a couple of ways in which we use these reliance measures of damages, we use these restitution measure of damages, but we cap them at expectation to make sure that we're not going to completely lose the plot on uncracking our egg. We don't want to get to a completely different world, except when we do, right? Like we saw at least one case, KGM, where the court was like, look, this is what the statute reads like. It says you get your cover costs minus your contract cost, and that's your measure of damages, even though that is a measure that was a windfall to one of the parties because of the cost plus contracts. They didn't actually bear the cost of that huge rise in the market. The court said, forget it, we're not going to worry about that. But what we did note is then something for an advanced class. And if you come back for sales, we'll do it then. Which is to say, those formulas are a bit messed up, right? They talk about, your contract market differential, that's your big measure of damages. And then they talk about incidental damages and consequential damages. And what I want to point out is that there are circumstances in which courts will say, yeah, but we're not going to use the whole formula. If you just use that contract market differential, like in KGM, that's enough. We're not going to tack on the consequential damages too. Now, there's a good reason for that there, which is that 2715 says, if you could have prevented consequential damages by arranging an alternative transaction, or if, as in KGM, they did prevent consequential damages by arranging an alternative transaction, then you cut off all the consequential damages that would have been there if you had done the alternative transaction, because you literally got the letters from somewhere else, and so you didn't get sued on your downstream contracts. We talked about all that. I say that just to refresh your minds. What we're going to do now is move in. There's only one piece of administrivia I'm aware of, which is reminder we won't be meeting on Wednesday. That's fine. We're well ahead in the class. We also don't have that many class periods left before the Thanksgiving break, so please do continue. I've got a really great rhythm now of meeting with groups who are working over exam questions and other questions. That's fantastic. Let's keep it up. If you find yourself not able to make one of those meetings, go ahead and get on my calendar with Outlook, and we'll do it on Zoom if we have to. Better again if we do that with groups rather than one at a time. There are 45 of you, so let's pack that together. So that's, I guess, the only thing that I can think of administrivia-wise. And with that, then I'll turn it over to you and any questions you've got about anything we've done in the class up to date, including most recently our discussion of expectation and then places where contract law uses reliance and restitution to substitute to solve certain problems in contract law. David?
So I have two situations where restitution is used. Is there only two?
There are two, no, of course not. There are two big ones where it's used in contract law. And then there's a third one, which is such a minefield that I hesitate to even tell you about it because it's going to hurt your brain. And there are a few others. But the places where it's used as a matter of contract law are restitution of prepaid amounts, or if you just undo the transaction, which a lot of times that's what especially a consumer plaintiff wants. You get a computer, it's got a cracked screen. What do you want? You want your money back. You want them to come take the cracked computer off your hands. Notice, that is not a measure of your expectation, right? Your expectation was to get the value of the computer, which you valued more than the money that you offered for it. That was your expectation. You're not getting that expectation, but you can see how that's a remedy that a lot of people want a lot of the time. So that restitution of the amounts that have been prepaid, that's a real common one. Or if the deal is undone, rescission as a remedy, right? We undid the deal. Well, if you undo the deal, the one party has to give back the stuff they got, the other party has to give back the money that they got, right? That's a pretty standard set of moves. The other one is not quite a matter of contract law, but it's so closely related to contract law that we have to talk about it there, which is if I sue you for breach of contract, like you mow my lawn, you screw it up. Halfway through, you do what I did, and this is absolutely true. There was a steel cable dog leash lying in the azaleas, and I was just mowing along and it caught it in the rotor, ripped half the front porch off the house, which was very nice. So let's say that then that happens, and obviously the rest of the lawn doesn't get mowed. Well, the lawn mower has now breached the contract and also should probably not be allowed near motor vehicles in my case. But second of all, they breached the contract, but they did mow half the lawn, and so they should get that amount. How do we measure that amount? Well, we could say it was like half of the contract price, but weirdly enough, courts don't. They just say, yeah, it's for amounts you haven't been paid under the contract price, the fair market value of the work that you did, right? And that's the second place you get it. Now, are there other places where we use restitution? Absolutely there are. I'm going to nail down a third one. A big one is just restitution. It's its own cause of action. I really can't stress this enough. These are both causes of action and measures of remedies. I know that's confusing. Keep them separate in your mind. We have been talking mostly about reliance damages as remedy for breach of contract. Restitution damages as remedy for breach of contract. But there's also restitution remedies as damages for restitution, unjust enrichment, right? That is under a different set of laws. We do not discuss them deeply in this book. They are under the restatement third of restitution, of restitution and unjust enrichment. And those are standalone causes of action. And I'll give you one further one, just because of like the great work we did last time on efficient breach. There's another place where it comes up a little bit. If you read that restatement third of restitution and unjust enrichment, one of the things that they say is you should get restitution for opportunistic breach of contract. That is, if I am aware that generators' prices are about to go through the roof because there's a natural disaster, and so I breach my contract with you to sell you a generator, and I sell it for a lot more money somewhere else, then the restatement third of restitution and unjust enrichment says I should be forced to disgorge. It's almost a barf remedy. I'm supposed to disgorge the ill-gotten profit I got by opportunistically breaching. And of course, the response to that is, yeah, fine, but that kills efficient breach of contract, and you got to be comfortable with that. So that's another place where it kind of fights right in the middle of restitution as a remedy for breach of contract and restitution as a remedy for restitution, unjust enrichment. Any other questions on what we've been doing so far? Yeah.
Alternative performance versus specific performance?
Okay. Alternative performance you will not find as a legal doctrine in the book. Alternative performance is my way of talking about the order of operations. You know, remember doing order of operations with math in like third grade, right? We're talking about the order of operations that courts tend to do in their comfort with remedies. An alternative transaction I use, that's my language. It's not on the bar exam. You're not going to find alternative transaction on the bar exam. What you'll find on the bar exam will be 2712, cover. That's an alternative transaction. 2706, resale. That's an alternative transaction by the seller, just like cover was an alternative transaction by the buyer. And you'll find these alternative transactions in the restatement, right? As we saw when, when we measured, hey, what would it have cost to go get alternative performance somewhere else? Just like alternative performance on the market as one of our objective measures of the expectation remedy, right? We don't know how much it would have been worth if you breached this contract. So one thing we can do is we can say, well, how much would I have had to pay somebody else to do that work? And that's a pretty good objective measure. It's not perfect, as we saw in the cases, but it's a pretty good objective measure. So that alternative performance, the point I want to make here is that that's an anchoring point for judges. One, they love alternative performances that you actually do. And KGM is the case that stands for that. They love getting the lettuce from somewhere else so much that they were willing to just give them a huge windfall for it. And the same thing's true of your contract resale remedy and your contract cover remedy of 2706 for resale, 2712 for cover. Again, look, if I have a contract with you to sell you my truck, and you don't go buy a solid gold-plated one, you just go buy like a fairly beat-up late 80s F-150, it just happens to have an engine that works, it's gonna cost more than the deal that you had with me. We know that because you wouldn't be suing me otherwise, right? If you'd gotten the same or better truck for less money somewhere else, there'd be no breach of contract action and you wouldn't have any damages. Right? So, and the court's totally comfortable with that. As long as you acted reasonably, you're gonna get more money because it loves that alternative transaction. Same thing with cover, right? If it costs me more to buy it somewhere else, or I resell it fast, I do a fire sale because you breached your contract, and now I gotta resell it to somebody else because I'm not a lost volume seller, so I gotta mitigate. I gotta mitigate by reselling. And I resell fast, and I get a kind of crappy price for it because I'm doing it fast, and because I'm not a person who resells trucks. Like I'm not a truck dealer. So for those reasons, I get a crappy price. Courts love it. They love it because, again, it actually is an on the cash on the barrelhead, real replacement transaction, and they don't have to read anybody's minds about what the damn contract was worth. It also serves as an anchoring point for the next step. Let's say that you either didn't arrange an alternative transaction or did arrange an alternative transaction, but you screwed up. You got the truck with the gold-plated rims, or I resold the car to my cousin Ruben, right, for $1. And then that you can see that that's commercially unreasonable resale, and we all know what's going to happen at this point. You're going to be limited to what you would have gotten if you had engaged in that alternative transaction. And so it's an anchoring point for our next step in our order of operations. Our first thing in our order of operations is courts are going to look, hey, is there a replacement transaction? Can we just fix this? Can we just go to the market and solve the problem and everybody go home? Mostly, to limit most of the damages? Fine. We either didn't do that or we did do it, but we screwed it up. Okay, we're going to kick it to an alternative hypothetical market transaction, and that's how it's going to set damages for these. We could have done something alternative and we screwed it up, or we couldn't do anything alternative because the stuff was just not there to be bought for love or money. Or we would have had to raise too much capital to do the alternative thing. So alternative transaction is not a legal doctrine. It is a way that I describe the court's preference for cash on the barrelhead replacement transactions to help the court with the basic problem of valuing a breach of contract, which runs immediately into our objective and subjective problem. Now, that is nothing to do with specific performance. And in a way, it's almost unfortunate that we would describe there's alternative performance and then specific performance, because the two things, they're just completely different concepts in this class. Specific performance is a remedy at common law. Specifically, it is, and I'm actually kind of wrong about that, it's a remedy more that is closer to equity than to common law. We just mix everything these days. Because it's a court order. It's a court order to perform the contract. And that's where we're going to start today with all metals. Remember, there's only really in contract law 3 places where expectation damages are not sufficient. We sometimes talk about damages at law. We mean by damages at law, we mean money damages. This is just part of our language as lawyers. Damages at law mean money damages. And you can see that because contracts are largely about making economic bets about the future, it's really hard to say, oh, you can't fix the breach of contract with money. Like with enough money, you can fix any breach of contract. And so it's very, very rare to be able to say, nope, actually money's not gonna fix this. 3 categories. Land, because the British aristocracy just had a thing about land. Land, unique items, Picasso's is what I use in this class, land Picasso's, and then as we'll see in all metals under the Uniform Commercial Code, sole source of supply and international trade. Those are our 3 you're gonna get it categories. Then there are invitations in the code to expand specific performance. Beyond that, there was a modern trend, and I mean by modern trend, I mean late like last half of the 20th century, right? That trend has gone nowhere really in the 21st century, but there was a trend for a minute of further opening up when you would get specific performance, and broadly speaking, courts hate it. Like US courts just absolutely hate it. The only thing to keep your eye on is that specific performance is a default remedy in international trade under the Convention on the International Sale of Goods, which is, of course, why we run into it when we run into it in all metals. Other questions, y'all? And in a way, like it's the same. It is an alternative transaction in the sense that it's saying, perform this transaction as a way of fixing it. Last point, practice tip, you don't actually ever get that. Because cases take a long time, and the goods are often sold on to somebody else. Even if you get specific performance, like in the race cars case, right? Even in Simeon, in the race cars case, you could make a pretty good argument for specific performance. Those cars were not generally findable anywhere else. That's why it was such a thin market case, right? You could have made the case for specific performance, but what are you going to do with that? Like the cars are gone by the time the court makes its order. And so if you want to make a very sophisticated argument, you need to realize specific performance really becomes, in those circumstances, what's called a kind of constructive trust. You're saying, the cars that you have were actually mine because a court has now, 5 years later, ordered you to sell them to me at the contract price. But so that what that really means is when you sold them, they were actually mine. And so the money you got for selling them should be my money. Specific performance doesn't often yield a straight up court order saying perform the contract. It often just yields a separate fight about how to time the market when the breaching party should have sold something one way, in fact sold it a different way, made money on that. Usually what happens under specific performance is you're like, well, you were selling my cars when you did that, and so I should get the profit on that sale, not you. Okay? Anything further on anything we've done in this class so far? And I mean anything, y'all. Yeah, Nate.
Just a clarification question about alternate transactions. So
Yes.
If you said the alternate transaction, you don't sell a fire sale, you don't get a good price, that's when the court uses the market value to determine if you should have or could have got.
No, you get a lot of leeway. The standard is this under the Uniform Commercial Code, and it's roughly the same under the restatement. The standard is, was the alternative transaction commercially reasonable? Now on the bar exam and on my upper level sales exam, I take a large area of law and cram it down into 3 things. Commercial reasonableness generally means you tell the other party that you're doing it, right? You tell the other party that you're doing it, you invite enough people to the auction, and you paint it. You inform, advertise, and paint it. Paint it is just stands in. Paint it just is anything that costs you less to do than the value you're going to realize by that gain at auction. So if you're going to make $1,000 extra by painting it for $300, you probably should paint it. If it's anywhere close, courts are like, nah, it's the... But can you see how much leeway that standard gives you? As long as you conduct a commercially reasonable resale, Let's say that your resold price is much lower than the original contract price. Court's response, so what? That's the contract damages. As long as you just did it in a commercially reasonable way. Same thing with commercial reasonably cover. We saw in KGM, they covered that lettuce for way more than the contract price. But they did their homework, they kept their receipts, they showed they shopped around, and so the court was like, yep, that's your measure of damages. The difference between the cover price that you had to pay out and the contract price, that's the amount more than the contract price that you had to pay out. So that's your damages, even though it was a huge windfall. So the point I want to take here is to say, look, as long as you conduct a commercially reasonable alternative transaction, the court is just going to simply look at how much that alternative transaction got you and how much the contract would have gotten you, and the difference is the damages. And they are going to go home and go golfing, and they're never going to be worried about it. They're so happy that happened. They are so confident about that, even though the prices are almost always going to be a little bit crappy, right? Because if I'm reselling something because you breached, well, I'm reselling it fast, and I'm not a reseller. And so we know I'm not a reseller because I'm not a lost volume seller. If I did, the resale wouldn't matter because it couldn't mitigate my damages at all. Right? So if I've got to resell it fast, I'm going to get a crappy price. Right? If I have to buy anything fast, what happens to the price? Goes up, right? And courts know that, and they're totally fine with that as long as you engaged in a commercially reasonable replacement transaction. Then they give you the straight difference, and they are so happy about that they can barely see because it makes their life so easy. And that's the core, right? That's the core question. Why do courts love this alternative transaction so much? And it's because it makes their lives real easy. Further questions, y'all? Yeah. Hey.
Just kind of definition. So cover is the actual alternative performance.
Cover is 2712. It is an alternative transaction arranged by a non-breaching buyer. The seller has breached. The buyer is covering that breach by buying the goods from someone else. And the degree to which that cover cost is more than the contract price, there's your damages.
Cover is not the action of like dispersing that extra expense to your franchisees. Okay.
No, cover is a very, very common, probably the most common alternative transaction for buyers of goods. 2712. Further questions, y'all? Yeah, Butcher.
Is there any requirement for notice before you go cover?
Yes, there is. Under two ways, but there is under general rules of industry practice because you have to be commercially reasonable. But there also is under the single most important rule. I don't know that it applies in this class, or I'd do it here too. This rule is so important that in my upper level sales class, I say, if you write this across the top of your exam, you get a point on the exam just for writing it across the top of the exam. If there's nothing else, even if it has no other bearing on the entire exam, if you write this as the first sentence, you get it. And it's 26073, and it says this. It says, essentially, you have to give the other party notice of your claim at the first possible instance, or you lose any remedy. This is not a statute of limitations where it goes 2 years for contracts or 5 years for torts or whatever. This is, you need to tell the other side as soon as possible under the code that you have a breach of contract action against them or lose any remedy. So yes, based on that backdrop too, you have to tell them right away or you're going to lose your remedy. And the reason you do that is because of something that we will see at the end of this class, which is that the court loves it when the problem goes away. And so the court would love it if you would send them a nastygram and saying, hey, we have a problem here. What the court would love is for them to say, oh crap, we're going to make that right. You had a crack in your computer screen? We're going to send you a new computer and we're going to give you some swag as like a bonus. And right, so the court wants that. That's called cure. The opportunity to cure the breach. That's what 2607 is about. 2607 preserves that ability to cure by making you tell the other party you've got a problem and telling them exactly why you've got a problem as soon as you've got the problem. But it's not quite as strict as like straight up, it's commercially unreasonable to cover without telling the other party, to cover without telling the other party. You usually don't, right? You're just like, no, I've got a problem. I got to go fix this problem because I need widgets, like right now, or my factory shuts down. So you go get them. You don't have to say, I'm going to go get them. You just go get them. Cool questions, y'all. Love how you're digging into this. Anything else? Okay. Well, then let's move on to all metals. We're cleaning up our big framework of alternative transactions, so to speak, right? With the ultimate alternative transaction, right? As Megan was pointing out, with the ultimate alternative transaction, which is perform the damn transaction that you promised to perform. And that's what all metals is doing. Ben, would you mind setting it up for me, please?
Yeah. So All Metals is a Michigan corporation. They are a distributor for metals in automotive and other industries. Liquidated is the industry leader in producing applied metals out of Germany. So applied metals are considered this is good. It's jumping ahead a little bit. The court considers this as good, but it's unique. They're one of one for very specific functions. And so All Metals and Liquidated enter a contract to distribute, or for All Metals to distribute these applied metals throughout the U.S. on behalf of Liquidated. And they go into a customer order protection, or the contract has a customer order protection clause. So under this, Liquidated is required to uphold it for, so it's a 10-year contract, and Liquidated is required for a period of 10 years to complete the goods or complete the orders as they're supposed to be completed. And so they go into the contract. All Metals is successful during this. They become huge in the U.S. I think their business grows from like something like $300,000 worth of quad metal up to like $8 or $9 million. So they become like a leader in this industry in the U.S. During this time, though, Liquidated actually starts buying out other distributors in the U.S. as well. So they start becoming the sole supplier of the good over time while they're in the contract. So later on, near the end of it, the end of the contract, the Liquidated suddenly terminates it and then decides that they want to have, instead of a gradual payment term, so something like people could pay like 150 days after whenever they got the good to supply it. Now it has to be cash and delivery, which is they have to pay whenever, or All Metals has to pay exactly whenever they get the good, has to pay Liquidated that. But they can't just by the nature of the way they're doing it, so essentially they become bankrupt, run that business if they did. So Liquidated, All Metals sues. They try to get an injunction to perform the contract as is. Liquidated doesn't want to do that. The court. Yeah. So from here, the court then looks to UCC 2716, comment 2, for specific performance, and they find that All Metals is entitled to performance. One, because the goods are unique and scarce, so there's no alternative source of supply. And then two, they're entitled to permanent injunction because there are three legal requirements you need to meet. One, irreparable injury. Two, All Metals. Two, a balance of hardships. And three, with certain public interest if this went through. So there would be irreparable injury because this would be like ultimately it would end their cash flow or it would create negative cash flow for All Metals. It would also affect them, their customers, as well as All Metals' reputation. So there's no other remedy they could do to see this through. Also, the balance of hardships, it wouldn't hurt Liquidated to actually have the injunction. Like it doesn't hurt them at all to do this. And then finally, for the public interest, an injunction would keep all the businesses flowing as they would as well. So basically help everybody.
Got it.
So because of that, the injunction should be upheld.
Okay, because of that, the injunction should have been upheld. Okay, do you want the injunction to be upheld? I'm gonna turn to Scott and have him run the other way. Do you want the injunction to be upheld, or do you think that this is nonsense on stilts?
I'll have the injunction upheld.
You're gonna go with the injunction being upheld here. All right. Then let's maybe turn to Scott for a couple of questions here, because that is not how almost every case in the United States going to go? I mean, let's just start with one basic principle. What law are we under?
We're under the UCC
Yeah, why?
because we're making widgets.
Right, right. Why are we under the UCC? This is a totally unfair question, completely unfair question.
Are you asking why we're under UCC, not the international?
The CISG, you damn right I am. Why is that? Because this is going to be a place where you can start with your argument. Well done.
We've got a German company and we've got an American distributor.
Look, if I do this to you on my exam, or if they do, or if somebody does this to you in the future, the law that applies here is the Convention on the International Sale of Goods. I don't know what the court's smoking over here. Like, they're just like, UCC! Which drives me to my point. There is a massive tendency from US courts to use the UCC, even when it's not applicable, because they're familiar with it, and their general view of specific performance is that it should not be performed. Now, in this particular case, you do fall into an exception. This is going to be a hard one to win, but let's start with why if this were a US case, which is very strange, right? Like, if this were a US case, the court treats it like it's a US case. If this were actually a US case, what are some of the reasons why the court might decide absolutely not? We're not going to provide specific performance in an industrial contract as a basic matter of law.
I think there's the idea that they don't want to work together, so why would we force them to work together? Are they going to even produce quality materials if they're being forced to produce produce the materials?
Right. And what are you going to say about then the idea that there is this, that they are, and this is where this comes out, this is the sole source of supply. This is the only place that you can get it from.
I think the way I would think of it from their perspective is, maybe Wickeder is the sole source of supply, but that doesn't mean all metals is. They're obviously trying to build up other distributors.
So they're trying to build up other distributors. And it's a hard one, right? For example, let's say that I'm a Coke distributor, right? And then Coke decides to terminate the contract. Sole source of supply? Or is Pepsi like that guy in the meme who's lurking behind the tree, right? Just be like, right? So sole source of supply, sole source of what? Sole source of what? It's not that we can't get maybe other metals in this industry that work out. And let's play with these elements of the injunction, because that's what this is. This is an injunction. It's a court order. This class, this standard, is a lot closer to the temporary restraining order you might get against an X, right? Or something you're telling another company they can't do Y. It's a balance of hardships. There's public policy involved. You're looking to see if the harm is irreparable. These are all of the standard moves you have to answer a court when you try to get a temporary restraining order, for example. These are how courts think about injunctions. So let's address some of these things. Let's just start at the back. He's saying public policy is served by enforcing this because the parties are going to do what they already promised to do. So why is that not? I'm assuming that because you're on the other side, your general view is, no, public policy is absolutely not served by this. Help me see why public policy is absolutely not served by forcing parties to do business together like this.
I think just the general issue with public policy is it's when we force someone to do something, mainly force us to do something that we don't want to do.
Yeah, and that is a real issue, right? Like the example that I always use is, what divorce court is going to order the parties to stay together? Can you imagine? That is the gut level response of US courts to these kinds of requests. They're just like, no. But further, why? And do you want to take a crack at it? Yeah, you, yeah. No, nothing? John?
A really good way to keep these companies locked in this tension is to force them for years on end to work together. This bilateral monopoly idea, where the market the companies, the consumers, everybody gets stuck in this forced relationship now between these two specific companies.
Right. So this idea of bilateral monopoly is pretty good. By the way, bilateral monopoly is drawing on what kind of language? Economic language. Okay. Can still somebody make the case for me that like locking these parties into a bilateral monopoly with each other over a long period of time, in fact, is going to damage public policy, going to damage public good? Correct? Yeah.
Well, if they're only in a contract with each other, it's preventing other companies from going into business with it, so it's therefore preventing the public good of the economy like expanding.
So it's gonna prevent competition. It's gonna prevent other people from moving in. It's gonna encourage opportunistic behavior, right? There's nothing like having your partner locked in order to upsell or raise the ante. Okay, I've got Riley, then Chris.
Yeah, well, the All Metals is just a middleman, and as Wickeder is moving into the United States, they want those clients. And so if the argument is that the clients can't get these super specific sole supply metal with different metal on the outside, yeah, they can. There's a new person. They're called Wickeder. They just entered the market. So there's no benefit to policy to enforce a system where there are more unnecessary middlemen.
Okay, so let's come back here though, because Dasha just said that there was a damage to competition, and you're like, well, but Wickeder's trying to enter the market and increase competition, right? Anybody got a response to that? Yeah, man.
If they were trying to increase competition, they wouldn't buy the only other company that could.
Yeah, they're not trying to increase competition, are they? What are they trying to do?
They're trying to eliminate any competition and create a monopoly.
They're trying to eliminate every competition, right? They saw that their partner developed the market for clad metals in the United States. And then they're like, huh, nice market you got there. Would be a real shame if something happened to it. Right? And they're coming in and they're trying to seize that downstream market. So we do have a lot of competition and anti-competition discussions going on in the subtext of this case. I think this back and forth is really valuable for seeing that. What's another way of looking at the benefit? So there's competitive benefit and lack of competitive loss going on in this subtext. What's another way of looking at what's going on here, though, that specific performance is absolutely gonna, if we order companies to do business with each other as a default remedy?
I would say that there could be an issue with innovation where you're allowing a long-term contract where you're relying on this tried and true method and you may not be thinking outside of the box to create something new with a new company.
Right. Sometimes you need to break a contract, and what do we call that? Efficient breach. Tell me why specific performance kills efficient breach, which is one of the major policy reasons why courts won't touch it.
Because in this case, Wicker must have determined that it would have made more money to both breach and to pay All Metals back for, their damages.
Which are going to be
A lot.
a lot. I mean, I think that I'm trying not to swear anymore these days, but it's going to be a beep ton. Why are their damages going to be a huge freaking beep ton? Just a huge barrel of beep. Lucas.
It's like 10 years of damages.
Yeah, why? Because their damages are?
Well, it's the expectation value of their contract, and they were contracted to continue supplying 4 years even after they stopped, even if they terminated the original contract.
Now say it again with turtles.
With what?
Turtles,
Because, it's going to keep moving down the market more and more.
right? Because what do we call those? What do we call those turtles all the way down, right? They have their direct market damages. You see that? Their direct market damages. The difference between what it would have cost them to buy the clad metal, right? What it would have cost them to buy the clad metal and what they actually had to pay. Hey, could they arrange an alternative transaction? No, they could not. Why? Because nobody else makes it. This is when this happens. Watch out for this scenario, which means what happens to their forward contracts, Lucas?
Well, then they're going to breach all of their contracts.
And then what are the damages? Yeah.
And they're going to breach all their contracts, and it's going to keep piling up.
Right? And what do we call that? That turtle collapse. Yep. Supply chain collapse, and that's what we call it as a matter of general discussion, and we call that as a matter of what kind of damages or remedies? these are consequential damages. And why does the inability to cover in a UCC case, if this were a UCC case, which it's actually not, but never mind that, but in a UCC case, what is the availability, or in this case, lack of availability of cover due to consequential damages? Lucas.
If you can't cover, you're required to cover.
Yeah, and then that would have blocked the supply chain collapse, right? And that would have blocked all those downstream consequential damages. And so we're looking at 2715, which says, if you could have mitigated those consequential damages by cover or otherwise, that's a direct quote, if you can mitigate these damages by cover or, what they say, cover or otherwise, then you lose any consequential damages that you could have prevented by cover. But that's not happening here because they can't get it anywhere else. Which means, holy mackerel, right? First of all, we're digging into why the courts got this major issue with specific performance. And one of the reasons they have a major issue with specific performance is they're not going to order people to stay married to each other commercially. And the reason they're not going to order people to stay married to each other commercially is because they're taking efficient breach off the table. But then when we start exploring the theory of efficient breach, right? Then what's your best example? What's your best response here to say, yeah, you know what though? Like specific performance in this case is probably better than letting the supply chain collapse. Here's the line. If Wicketer makes all metals as good off as they would have been if the contract had been kept, and then is still making money for itself somewhere else, largely out of monopoly profits in the US market right now, right? Then isn't that efficient? Isn't that good for society? Isn't that more wealth for everybody? And your response there is to say efficient breach is not appropriate here. Yes, specific performance kills efficient breach, but efficient breach is not appropriate here because
efficient breach is not appropriate because maybe I'll quick answer.
yeah, sure, go ahead, Fletcher.
Because the extra money that Wicketer would make would be taken from the consumer surplus of the auto manufacturer.
Okay, so one, the extra money that they're going to make is going to be taken out of market through monopolistic rent-seeking behavior. That's a rough one to say, and absolutely true, and probably what was driving the court to this. Notice that that's not what the remedy's about, right? That's what's going on underneath, is this market hijacking story is driving the court to its result. All right? Nate, you were going to say.
I would say the cost would be just too high for it to be efficient. There would be so much knock-on cost that it would be incalculable and extremely high that
Right.
it can't be an efficient.
Look, everybody put on your all metals hat. You are now all counsel for all metals. Now, you don't have to yell objection, Your Honor, out loud, but you can yell it in your brain. I want you to hear the objection in your brain. I am going to say something, and I want you to hear the objection in your brain. Here it is. Your Honor, specific performance is not an appropriate remedy because when one party can make the other party whole and still make more money, we turn toward efficient breach as a way of allowing the flexibility in contracts necessary to run the society. Where's the objection? Lim.
They can't be made whole.
They can't be freaking made whole. Like first of all, we don't believe you because making them whole would be tracking this whole freaking supply chain collapse. Absolutely not. We don't believe you. And that is the major objection to efficient breach theory. It sounds nice. Just remember, if you wanted to make all metals whole, what would the world look like if you were really going to efficiently breach?
I think we're forgetting about another movable good in this case that's really important, which are big stacks of paper that are sales contracts. Why can't they just acquire the sales contracts, maintain the relationships, and the market doesn't collapse? I think the judge is afraid because it's the 2008 auto market is crashing. It doesn't need
I think this is a really great point. Let's say that you're the attorney. You're now in-house counsel for Wicketer. And, but you're speaking English. And so you go in there and you say, and you're like, hey, I heard we were going to do this to the all metals contract. Now you've got two things to say at that point. What do you say to the C-suite? What do you advise them to do? Talia. Mitigate as much as possible. What would that look like? Try to prevent the supply chain from collapsing? Yeah, but they're like, nah, but we want to hijack the US market. So we gotta go with somebody who's a little bit more hardcore, fully owned by us in the US. But you got the right idea, Talia, yeah.
Open a distributor company beforehand.
Well, that's what they were in negotiation to do that. But remember, we're back on this question of we don't believe you when we say you're going to make all metals whole. Scott.
Do you try to acquire all metals first?
Sure, at least. I mean, that's a great place to start. Let's try acquiring all metals. Got any other ideas that aren't absolutely insane, like causing a supply chain collapse and then footing the bill for it? Because that is not some wise C-suite planning. By the way, also, just because this whole conversation would probably still have been in German, because German, the legal tradition in Germany is very, very, very traditional. So I joined up with like a legal PhD group when I was there because they were the only group of people that would actually just speak German to me. What else are they going to say about this supply chain collapse? Yeah.
Well, I'd probably just tell the C-suite to be patient because you've already ended the 7-year contract, or you've reached it, and you've kind of dealt with that. You're just worrying about the 10 years. But if all of these companies in the U.S. that are buying from All Metal know that All Metal's time is limited, they're going to have to come calling to you.
It's gonna time out, and it's gonna time out faster than 7 years. Wait, that's another great one. Give me another one, Liam.
You could just cover the contract that All Metals is breaching, so there's no consequential damages for All Metals.
Yeah. What's that conversation look like? You call All Metals. Now, you might call them and say, I'd like to buy your company, right? Or you call them and you say, what? Look, we've already breached the longer contract. Everybody knows that this deal is coming to an end. Yeah.
Why would All Metals give you the information?
Why would All Metals do any work for you? This is where we have to really interrogate the theory of efficient breach. To really interrogate the theory of efficient breach. Under what circumstances would All Metals be like, okay, cool, like I get it.
Would they be required to in order to like mitigate the damages? Would they be required to like help you?
Wow.
build the contracts?
I mean, on the one hand, no. On the other hand, we just saw that in Simeon, right, where the court actually entertained the idea that the guy had to buy the cars at a higher price from the same person who breached the contract as a measure of cover, that sort of self-cover argument. Yeah. Alternative negotiations start making the other party look worse and worse. It's true. What kind of deal? Look, let's say that we understood our economic theory. If we really believed in it, let's just set aside all of my natural grouchiness about it and really lean into economic theory and say, wait a minute, now hang on a second. There's a lot of money on the table, at least between these two parties. There's a lot of money on the table to be made by entering into a monopolistic framework in the US market. And if it's true that it's possible for Wicketer to change this relationship and make $1 billion, then what must be true for All Metal?
They can make some money as well.
They could make some money as well on this. How does Wicketer make this profitable for All Metals? Liam.
They say, we will sell to your constituents, like the contracts below you. It would be the same price that they're selling it to them, so then they can just, sell all their assets, make money there, and they're gonna have no consequential damages because the alternative performance is gonna be identical.
So we wouldn't want to just make them whole, right? Aiden, we'd want to?
I was gonna say, could they attempt to like negotiate a buyout?
Yeah, just straight up. I mean, buyout's the cleanest way of describing this, right? And it probably would take that form. But what I want you to do is see why this is happening. This is happening because the breaching party is going to say, instead of breaching, they're going to say, hey, why don't we renegotiate this in a way that's going to be advantageous to you too? If there's that much money to be made in taking over this market, why doesn't Wicketer cut All Metals in on it while cutting them eventually out of the market? Saying, look, we're not going to do that. We're not going to extend these contracts any further. But what we will do is we will cut you in on our conquest of the US clad metals market. in exchange for you bowing out gracefully. And that would actually be an efficient breach, where it is Pareto efficient. Somebody tell me why that is actually Pareto efficient. Justin? Yeah, no party's made worse off, and at least one party's made better off. And in this case, as is the basic theory of this course, all you did to supercharge Pareto efficiency was to say, yeah, both parties are better off. That's our bargain for theory of exchange. The idea that we can come to some deals and both parties can be better off. That is the heart of efficient breach. Under the heart of efficient breach, the idea is breaching a dumb contract could be better off for both parties, but it's the could be that's the problem. Because we are not in a conference room negotiating a buyout of All Metals by Wicketer. Where are we now? In court. And do we believe for a split second in efficient breach when we are in court? No, we do not believe for a split second in efficient breach when we're in court because? Yeah, because making the non-breaching party whole is not a thing that happened. They had to sue, and we don't come cheap. And this is years later, and there's been business disruptions and all kinds of additional damages. So it's a little bit rough to show up and be like, efficient breach. So where are we so far? Well, we're here. Specific performance is very rare in US courts. That's why this case is in the book. It is showing you like the 1 in 1,000. It is very rare in US courts. The reason it's very rare in US courts is because it destroys efficient breach. Efficient breach, though, has got its own problem, which is it's not efficient. It's just not, given how much we cost and all of the transaction costs of actually getting the money to the non-breaching party. And so you often want to just sort of call opposing counsel on the carpet and say, yeah, no, like we're not, you could have made us whole, but that phone call didn't happen. Now, mind you, as Lucas pointed out, as Scott pointed out, if that phone call does happen, your theories start looking stronger and stronger when they turn you down. Because you gave them a way out, and they didn't take it. Okay, cool. Ben, back to you then. Specific performance sounds like it is necessary in this case. Why is ordering, let's spin it out, why is ordering, give me more reasons why ordering Wicketer to perform this contract as written with All Metals is a useful remedy.
So it could be good. Because it wouldn't hurt Wicketer like an all like to do it. So it still would help them if they did. Also, it could be good for people like All Metals like going in the US for their reputation, keeping people at work, like keeping their employees going versus like a buyout.
How do we feel about the employees argument? Bailey? I was going to say, NIPSCO, right? Like that's the answer. I was like, yeah, NIPSCO. But we're on to something here. What is it about, you said, mentioning entering the US market. What is it about the international context that makes, and this is true, specific performance a pretty common remedy under the CISG? We've been doing this whole thing under the UCC. Why is it real common and actually the default remedy under the CISG? What is it about the international context that makes courts more likely to go, yeah, we're going to make you do it?
Don't they just prefer promise-keeping theory? It's just like, you made it, you have to do it.
One, I do think that there's a lot more of the continental tradition of promise-keeping theory. I will say this, for upper-level classes and in your practice, the CISG is a lot more informed by UK common law, which is ironic because you want to guess what country's not a signatory of the CISG? The UK. There are 3 systems of international trade. The UCC, which usually is determined by contract, the CISG, which is the background default rule, and then UK Admiralty rules in general. They've got their own deal going on. They didn't actually sign on this. But at least for this point, like they do have this promise-keeping component. Why else, Scott? Why else would we do?
Is it just global supply chains?
Yeah, it is. Tell me more about that.
Well, you just have so many different supply chains and countries involved, and so if you were awarding specific performance, lots of things would break down and goods would get where they need to go.
Here's a question for you. Let's say that you are in a car transaction. We'll just go with cars, right? So you've bought a car and the seller breaches. Now, do you want that seller to be Ford down the road? Or do you want that seller to be like one of those custom UK-made minis. What's the problem? Go ahead.
You need the custom, otherwise it's a lost volume seller.
Well, one, you do need, although everybody in these cases are lost volume. Do you want to try to replace a UK car or a US-made car?
Oh, like an alternative,
Yeah.
the alternate performance may be like way harder to do if like you're doing it across the world.
Yeah, that's what it is. I think that's the big answer, is that we do need to maintain global supply chains, and we also really have to keep an eye on the fact that these alternative transactions get rough as we are dealing with other legal systems, as we are dealing with other languages. I just spent a number of weeks on the phone with various organizations in Belgium and in Switzerland and in Germany, and my German is fine and my French is old and rusty, and you can imagine how that went. I'm just trying to arrange all these transactions, and I feel like I'm juggling chainsaws. Like I can barely manage to keep up, and I'm fluent and a lawyer. Can you imagine like somebody who's not in this area trying to arrange an alternative transaction in Slovenia? Like just, where are you gonna start? Who would you call? Hell, what do they even call that area of law? That's what ChatGPT is actually good for. It's figuring out like, what the hell do even people call this? They'll tell you. It's pretty sweet. Okay. So I think we can see why then that is the default remedy in thing. Okay, so then finally though, you do have one last point which that has such an obvious answer that I won't make you say it. You only get specific performance under the US system, if we keep this under the US system, you only get it under the US system if it is a unique good or if it is land, which is the same thing as unique good given the strange fetishes of the British aristocracy. So that given that unique good thing here, is this unique good?
In this case, it was argued that it was.
Is there only ever one all clad? No. Tell me why it's not unique.
Because lots of companies have made it or try to make it.
Well, no, wait a minute. Hang on. Do lots of companies made it or try to make it? Annika? No? Okay. Justin?
I was going to say there's lots of companies that make it, but not any of them are as efficient as
Right. Yeah, so they're, go ahead, Riley.
the metal itself isn't unique, but the machine that makes all the metal is unique. The specific type of metal they want can only be made by.
Right. Ben?
I was gonna say that it's basically making a widget, and widgets aren't unique.
Yeah, I mean, it is a widget, and like if I fed this to you in a normal case, can you see how you'd be out of your mind to consider this? Like, it's not unique, but we're trying to investigate. There is something of uniqueness, like I can smell uniqueness in the room, right, Scott?
Or is it that the widget isn't unique, but we're the only ones that make it?
Yeah,
So
and
it's
that's
like a unique-
that's your winning argument. Why do you get specific performance in this case?
Because there's only one widget that we have, and the only supplier that comes.
They're the only one that we have. That is, we now have, does everybody see how sole source of supply starts to smell like uniqueness, even though it's not? All right? And that's why we're going to now amend our rules after this. You can get specific performance under the Uniform Commercial Code for land, Picassos, or sole source of supply under the code. And the code actually throws open the gates. They say even other proper circumstances. They wanted to liberalize specific performance. Scott, what's your argument in the next case to the court? Are you going to just go, oh yeah, clearly specific performance is an appropriate remedy in these circumstances? Scott's not given an inch. Why?
Because of all the like efficient reach and
Yeah, and in the next case, you think the court's going to go for it? I mean, just not a chance. I cannot describe to you how incredibly hard it is to do that. And so the background rule remains Scott's rule. Ben takes this case because it fits the characterization of sole source of supply. But overall, the invitation that the code extends, and it does, go read the statute, it extends the saying, you get specific performance in other proper circumstances. That was meant to open the doors to a liberalization of this global standard of making people stay married. And Scott's like, nah, I am going to kick your ass all day long and twice on Wednesdays. You keep trying this stuff. This worked here. It's not working in the next game. Not a chance. All right? So that's what I need you to take out of this, is that it's Land Picasso's sole source of supply, why sole source of supply works in this particular case, the antitrust problems, right, that Dasha and Riley were going back and forth about that caused the court to go, okay, I see what you're doing. You're taking your supplier who developed the market in the US and then you're jacking the market that they made without paying them for it. So I'm going to let this go on sole source of supply because I'm mad now. And because telling them to perform the contract as written would actually be a remedy because it's actually going to fix the problem. And so this is this 1 in a million case where you're going to get it. Land Picasso's sole source of supply. Chris.
So in a US only case, can you make the argument that not the actual item is unique, but the sourcing is?
Yes, they reference in the official comments sole source of supply. It is set out as a third category under the code. It's not gonna work under the restatement, but in a code case, it'll still work in the US, except Scott's headwinds are just there. The court's not gonna wanna do it, and it's gonna put pressure on our stretching motion, right? To say, are we really talking, like, is it really unique? Or like, is Pepsi a substitute for Coke? Which is what they asked me about because I used to practice law at Jones Day in Columbus, and Columbus is owned by Pepsi. And they would go in and we would say, I'd like a Diet Coke because Diet Coke is the truth and the light. And they said, is Pepsi okay? And I had to say, no, it's a matter of law. Pepsi is not okay. But you can see, like, the idea here is that stretching and contracting and finding of alternatives is wind under the court's wings. Like, it's gonna want some serious efficient breach here. It's gonna want to let the parties go their own ways. It's gonna hate, among other things, it's gonna hate having to be like the parent in the transaction. What happens to the court if it tells them they have to stay married?
They have to make sure they stay married.
They have to make sure they stay married. What's that look like? That looks like the parties are right back here in court next Wednesday because they're not doing what they were supposed to, Your Honor. And like, holy shit, the court does not want that, right? So there's so many reasons. The answer is yeah, you get it. But be aware of the headwinds. And if you're on the other side, use those headwinds. Lean into the headwinds. All right? Any questions on all metals before we move on? Yeah.
So we know with the CISG, it's generally more in favor of using specific performance.
It is.
If we decided that they were going to do this under the CISG, how would we do it?
Okay, so had they decided they were going to do this under the CISG?
Yeah,
I mean, the answer would have been real short opinion. The default remedy under the CISG is specific performance. Plaintiff's request for an order of specific performance is granted. Like, they couldn't have been any faster. Just be like, do it.
they don't have any differences of view on like sole source of supply or anything.
Nope. They'll do that for widgets. All day long, they'll do it for widgets. Y'all, practice tip. I told you before, I think you wrote it down. If you didn't, come up with it. Figure out a way to reference it on the exam. I don't know. It is one of my favorite things. Your American company does not want to be under the CISG. Give me the 2 reasons it does not want to be under the CISG. The one we know is specific freaking performance as a default remedy. What's the second reason your company does not want to be under the CISG? Jake? No parole evidence rule, which means, holy crap, they could just be like, yeah, but we said we weren't going to do what the contract actually says we're going to do. And the court has to sit there and listen to you say that on the stand and be like, I don't believe you, dude, but like I have to sit here and listen, let you say that the writing on the back of that we agreed orally that the writing on the back of this contract was not going to apply to us. They had to sit there and listen to them say that. Y'all, your clients don't want it. Here's how you deal with it. You say, we're going to apply the laws of the state of Virginia or the state of Texas or whatever. So you apply the laws of the state of Virginia, excluding the CISG, because otherwise the CISG, excluding specifically the CISG, because the CISG is a treaty, it's an international treaty, and courts have said in the past, international federal treaties are part of state law. And so if you just say the laws of the state of Texas, well, you've included the CISG as part of the rules. To get rid of it, you say, we're using the laws of the state of Texas, excluding the Convention on the International Sale of Goods. That's how you get rid of it. Your client wants you to get rid of it. There, I've made your first year's paycheck worthwhile. Just tell your partner that, and you will save so many millions of dollars for people who otherwise have to fight this stuff in like some country. They don't speak the language. They don't understand what's going on. It's a very strange thing. And also they're being ordered to perform contracts for widgets across the entire planet. And you're like, you could go next door and get the widgets. Of course, like I don't care. Specific performance. Okay, cool. Tully.
When you're expanding the community context, if the companies were based in America,
Yep.
does it become unreasonable to try to find those goods in another country, or is it?
Cross-border cover transactions are a legit move. Like if you have a potential cross-border cover transaction and you don't take it, you lose your consequential damages under 2715. Okay, let's move on. And we're going to go to Minihane. All right. And Alexandra, if you wouldn't mind setting up Minihane for me, please.
Sure. So the plaintiff, MPS, is the developer of Gillette Stadium, which is the home field of the Patriots. And in 2002, MPS entered into an agreement with the defendant, Paul Minihane, for the purchase of a 10-year license for 2 luxury seats in the Club 3 section from 2002 to 2011, where Minihane would pay $3,750 annually. And this agreement included an acceleration clause where, in the event of a default, there would be liquidated damages in the full amount under the contract. The defendant paid $7,500 in the security deposit, and then $2,000 towards the license fee for the 2002 season. He then attended all but 1 game of the preseason, but he did not make any further payments. After giving notice to the defendant, NPS accelerated the payments and then filed a complaint seeking the full amount under the contract.
Absolutely. And this is fairly straightforward. What's this doing in the book?
Liquidated damages.
Hey, before we even get started, because this is going to get ugly here in just a real quick second, because like this should have reminded us of a lot, right? Like this case should have reminded us of a whole bunch of stuff we've done already. I'm going to ask about that in a minute, but for now, liquidated damages. What are liquidated damages?
Liquidated damages are just like they want cash for what they feel like they're owed. And in this case, it's the full amount.
What they feel like they're owed?
What they're owed in accordance with like what they put in the contract.
Yeah, this is like, you want to talk about making the job of the court easy? How about this? Damages for breach of this contract will be $1 trillion. Easy, right? Okay, first off, if damages for the breach of this contract are $1 trillion, then what?
That's pretty punitive.
That's real punitive. And what does that mean if damages for breach of this contract are $1 trillion?
It's not, I don't know, I'm not sure what you're trying to get to.
It's an excess of expectation.
It's in excess of expectation, which means
No efficient breach.
no efficient breach. They're not going to breach that contract. Period. This becomes a court order forcing you to breach. Oliver Wendell Holmes said, and I agree with him, a contract is a promise to perform or pay, and $1 trillion as a agreed upon remedy takes the whole idea of or pay off the freaking table. You're not going to do that. It's so punitive, right? It's so punitive, this is called a penalty. So this is our big distinction when we look at liquidated damages. We say, is it a reasonable expectation or is it a penalty? Now, before we get going, do you happen to know the black letter law here of what is a penalty and what is a reasonable estimation of the party's expectations?
Yes, so a contract provision that plainly establishes liquidated damages should be enforced as long as the damages are not disproportionate, and liquidated damages are enforceable in light of actual or anticipated damages. They are not enforceable as a penalty, and mitigation is irrelevant in assessing liquidated damages.
Okay, so many brilliant things that we had right there. The first one is, here it is, actual or anticipated. The thing you write down has to be proportional to actual or anticipated damages. That means that if you anticipated high damages, but you don't actually suffer them, don't worry, it's okay. If you didn't anticipate damages, you just put a big number in there because you're like, what's the biggest number I can put in there? But your actual damages turned out to be that much, it's okay. Actual or anticipated damages. And then we are going to have to talk about why mitigation, why that sort of throwaway line about mitigation, which is absolutely right, is in there as well. Okay, but I wanted to give you the black letter law and why before we get into it. Liquidated damages are the damages that the parties agree on. It might seem like we don't have a lot to say about them because they're the amount that's written in the contract. The question is, are they reasonable in light of the actual or anticipated damages of the parties? And if they are, we enforce them. And if they're not, we don't. And we don't enforce them if we think they're a penalty, because that would destroy efficient breach. And it would mean that it becomes a punitive promise to force one party to perform rather than letting them off the hook. Okay, cool. This is where I'm going to start with this. I'm going to give Talia the other side of this. Do you want this as, yes, we go with these as liquidated damages, or no, these are clearly a penalty? Yes, these are clearly liquidated damages. Give us a brief statement of why these work perfectly well under the standard you've just articulated.
They're pretty much like the full amount of damages under the contract. We were unable to find anybody else to proceed, so I mean, this is pretty much what it would have costed if they had not breached and they had, paid for all the reasons.
Okay, yep, that's the basic setup. Talia, you've been handed a couple of, like that picture's right across the plate. What's your response there?
But they're not reasonable damages?
Yeah, they're not reasonable damages. Why?
Because if you...
What were the damages in this case?
65,000? Well, it's 3,750 annually times the remaining amount of years, which does not add up to $60,000.
No, it doesn't.
Which was what I was confused about.
But also, remember what you're trying to say is that the amount, how much was the liquidated damages here? How much is plaintiff asking for?
I thought it was 65 is what it ended up being.
Right, 65, right? And given this very loose standard, remember the court wants to follow the contract so bad. The court's got a golfing tea time and the court's like, I am out of here. Talia, you're going to have to talk real fast. What number would you love the actual or anticipated damages to actually be? Like if you could make up a number, what number would you want the damages to be so that you can show that the $60,000 is bullshit? Like if you could make it up, just like the real damages in this case are,
0.
Yeah, I would like to say that too, except they are 0. Tell me why.
Well, because they could theoretically just sell the seats to someone else.
Okay, and they're clearly going to do that. And in fact, what evidence isn't there in this case that like they freaking...
It's early Brady days, so seats are going to go for much more money.
I mean, this is, first of all, okay, we just quick sideway, because you're like so right. I got just quick segue here. Okay, look, what is wrong with this guy?
He lost the best seats in the house at probably the lowest price that they have been for the last 20 years.
I mean, like just not as dumb as one bag of bricks, maybe two, like three distinct bags of bricks. And not just that, not just because of losing out on like the Brady days, et cetera, but like what else? And then maybe it's not him. You know what? It's not him, it's his attorney. And I do maintain that his attorney has got, why? Talia?
Well,
What does his attorney do wrong here?
They don't say how much they could have resold them for.
Well, one, they don't.
And they could have sold, like, while he still had to rent them out to someone else. Why?
Y'all, why? Why breach? Why freaking breach? What is wrong with you for breaching? Go ahead, take tickets from other people for more than you're paying for it. Don't breach, keep the seats, get a fat stack of cash instead of breaching and getting sued. This is like one of the only times in my entire contracts career where I have ever seen anybody who's got an asset that's in a rapidly rising market who breaches the contract. And let me tell you, if you ever detect that that is happening, that the opposing counsel or that the other side has breached in a rapidly rising market, what do you tell your client if you're on the other side of this? Yeah, don't go to court. Like, just laugh all the way to the bank. This is amazing. This is hilarious. They had you locked in at a lower price and the value of these seats is going up and up, and then they give them back to you? Are you kidding me? Don't ever do that. Practice tip. If you notice that that's where your client is because of, say, a liquidity problem or something like that, freaking sell the thing yourself. Take the fat check. Pay off the breach. Keep the rest. Why would you do this? Okay, but now this just raises further problems, right? How can we say with a straight face that the damages here are zero? What does this case remind you of? Right?
It's like a lost volume seller.
Oh yeah, it's absolutely a lost volume seller case, only in this case, are they lost volume sellers? No, they're not. Why are they not lost volume sellers, Nate? Because there's only so many seats in the stadium. Now wait a minute, under what circumstances might we say, yeah, they're clearly lost volume sellers of seats? Yeah, if they hadn't sold all the seats, if they can meet additional demand, right? But remember our Craftsir discussion? Anybody want to tell me how the second lease of these seats is logically related to the first? Yeah.
They won't be able to sell them again if you haven't breached it.
Yeah, there's a but-for causation. They would not have been able to engage in the replacement transaction if they had not breached the original. The breach is the cause of the replacement transaction. So under either of our prongs in Craftsir, the damages, Talia, are bupkis. Okay, coming back now. What are we going to do about that?
I guess I would say that we did try to sell the seats, and that wasn't possible. And it's probably because luxury seats are really expensive, and so not just anybody can afford them. So we do have damages.
We do have damages. We did try, yeah.
Dude, they just won the Super Bowl.
Luxury seats are really expensive.
They did sell, yeah, right. And if you look into the record, they did sell the seats. So, Talia, what's your response to that? They said they tried, they couldn't sell the seats, and you're like,
either you were charging way too high, or
yeah, unreasonable replacement transaction, right? Or like you got too greedy. So that one you're looking like you're in trouble on, Alexandra, but it's okay, you're going to win anyway.
Mitigate those damages.
Tell me more about that.
Well, first of all, if we're a lost volume seller, we have no duty to mitigate.
Because if we still have extra seats, we have no duty to mitigate. Tell me why. Perfect.
Because we could have made 2 transactions,
Yep.
and now we're only making 1.
And so replacement transaction doesn't matter. We could have had us and the law firm next door. 2 box seats, right? Not just one. Great. And, okay, your response though is? I'm going to be right back.
okay, that they're not a lost volume.
That they're not a lost volume seller, Jake, because?
Because they wouldn't be able to sell the seats again if you hadn't.
Because there was a but-for causation. These were the only seats that came available because of the breach, and they were only able to make a replacement transaction because of the original breach. And we're back with you, Alexandra. You're still going to win because?
Because mitigation is irrelevant in assessing liquidated damage.
There it is. Boom, right? Just like finally dropping the hammer at the end of the case. Just like, yep, I know. In fact, we're getting a hell of a windfall here. It's okay, Your Honor, though, because it's in the contract. And because we don't have to mitigate. We agreed ahead of time that this is what the damages were going to be. Was this correct? Now, here's the thing. You do have to stick it to black letter law. You win, but you're going to have to stick the landing. So was this correct? That is, was this disproportional in light of actual damages?
No.
In your heart of heart, Talia, sorry. Talia, is this unreasonable in light of actual damages?
Well, if it's market price, then
Yeah, like what are actual, everybody here, what are actual damages in this case? Absolutely zero. And if you don't see it, like come talk to me about football or something, like, because holy crap, damages are zero. You're still going to win. Actual damages are zero, but it doesn't matter.
I would say
because we put it in the contract, and what's our standard? This has to be proportional in light of? Tell me about anticipated damages here.
Well, first of all, we did anticipate it in the contract. You knew exactly how much it was gonna cost you for each. And in this case, that's how much it would cost if you did, I don't know.
Yeah, no, you're on the right track. Chris, go.
In assessing reasonableness, the court is still saying, look, it's at the time when the contract.
That's the thing. The courts don't look at what happened later on, except if the argument is that the damages were not anticipated, but they are actual. Then it's going to look at what happened, like how much did you actually suffer. But generally speaking, the court looks for liquidated damages. Were they reasonable at the time the contract was made? Hey, what didn't we know at the time the contract was made? Whether or not we'd be able to sell the seats out. Whether or not we were going to win the Super Bowl. Whether or not Tom Brady was going to get sanctioned for this, that, and the other. We don't know. We don't know. Anticipated, right? At the time of the contract, that's the dividing line. That's what sets it apart. Everybody see it? I do need you to see underneath it why this is bull crap, right? Like they clearly got double paid. They got paid again for those seats at a higher rate because yes, they did get somebody else in those box seats. Are you kidding me? So they filled those seats, they got paid that way, their damages were zero, they got paid again through this massive liquidated damages thing. Hey, even worse than that, normally under liquidated damages, like what's missing here, if this is the wild part about liquidated damages. How do I do this without making it complicated? Remember our discussion earlier? It was related to 2714. If you guys are hardcore out about your code sections, you can go take a look at 2714. We haven't talked about it in enormous detail. But 2714 says essentially, and a number of other ones like this, say essentially, look, if I get something and I wrongfully reject it and you force me to pay for it. Well, if you're going to give me what's called an action for the price, that's forcing me to pay for it. This is your standard thing on Amazon. You get the thing, you don't pay for it. Well, what are they going to do? They're going to force you to pay for it. But the thing is, you get to keep the thing. Do you see that? Does he even get to keep the thing in this case? I just want you all to see how far down the rabbit hole of it, how much work anticipated does in this case. It's a lot of work. He has to pay the full acceleration clause on the full amount, doesn't even get the box seats, which they are then permitted to go and re-give to somebody else for additional money, and they get the fat stacks of cash all at once. Liquidated damages are just brutal. All right, we've done a full run through. What you should now know is where we started. That is, damages must be proportional in light of actual or anticipated damages as anticipated at the time of the making of the contract. We now know the rule, but we also have a little bit of a gut feeling about how ridiculously powerful this rule is, because let's be clear, actual damages in this case were zero. Jake.
Do you know why the court also awarded attorney's fees?
I don't. Except, sometimes courts get mad when something's obvious. It is rough arguing against liquidated damages. You agreed. But no, I don't know why there would be specific awards of attorney's fees in this case.
My question kind of just tied into that. Why would the court come down so hard? And was there a way for them to find a different thing to be more just? That maybe not?
Yeah, I think the court could have done it differently. Talia, if you had a friendly court, what would you have, if I make you the judge now, and you want to drop the hammer on this, you're like, nope, this is a penalty. This is not a reasonable liquidated damages clause. This is what we call a penalty and therefore is void as liquidated damages. How would you make the case that this is a penalty?
Well, say the amount was unreasonable.
Yeah, the amount was unreasonable in terms of actual damages, which makes it unreasonable to uphold. It makes it unreasonable if your actual damages are zero. And I think everybody in this class came into this case knowing the damages were going to be zero. Then what does that do to the standard of law that Alexander just won on? If you know, yeah, go ahead. Then you should maybe anticipate that the damn damages are zero. You use it as an evidentiary standard. Well done. Well done. Use it as an evidentiary standard. You're like, look, I get it, but like, you have to understand your decision of anticipated damages also has to be sane. And no sane human would have looked at this, is the argument. Can you come back in the other direction? Sure, they were still building the stadium, right? But at least the argument is no. Actual damages were zero. Any lawyer who looks at this for 30 seconds goes, you're not lost volume anymore. You're going to replace this stuff immediately. Your actual damages will be zero, which means that it's probably unreasonable to anticipate that your damages are going to be anything other than zero, and certainly an acceleration clause where you don't hold the goods available. That's what I would hammer on. Saying like, he has to pay for the whole contract, and then you take the seats, which you claim aren't worth anything, and then I've got receipts here showing that you did get $1 billion for them? That starts looking pretty ugly, right? So understanding why the court, what's going on underneath here helps you construct your argument. But I mean, as it's written and given how badly this was argued, I think we can see that Alexander's side takes it. Okay, any questions on that one before we move on? Aiden, yeah?
So does the court, like they just know that as soon as he pays these damages for breach, they're going to turn around and sell these seats for way more.
Yep.
Hands are just tied to the contract.
Yep. And because of the black letter law, Alexander successfully argued the black letter law, which is the damages must be measured at the time of the making of the contract and must be reasonable or must be proportional to the actual or anticipated damages. And here it's an anticipated damage. You might, though, the way you push back is what we just said, which is there's no actual reasonable process of anticipation that yields this result. Right? But courts want this so bad, and that's your takeaway. They want nothing more than to have the subjectivity problem of value solved for them by having it written in the contract how much. Talia. Yeah, fire away.
The $65,000, the $3,000 times like 8 or whatever years.
Yeah, that's not getting anywhere near it. Appreciate it, Leland. Lucas.
Is there any way that liquidated damages could be considered like a term of the contract, almost like consideration, like he was able to secure a better price because the damages terms were so harsh?
Yeah, this is, again, my favorite German word, Jein. Let me be clear. As a matter of law, no, because we've got the black letter law of penalties. But absolutely. Do you remember my discussion about when we were doing the furniture case with unconscionability, Walker Thomas Furniture? And we started talking about some of the new contractual frameworks, which people who are under, remember our argument was like, look, this looks unconscionable. It's really rough to let Walmart kick in the door and repossess everything you ever bought from Walmart just because you didn't pay for like one set of AirPods. That's rough. On the other hand, who else was going to give the plaintiff credit under those circumstances? There was no viable collateral that she could have given anybody else to get the price down, where she had all this collateral that was already with them to get the price down. And at that time, we were talking about things like this. Remember when I said that the modern version of this were starter interrupt devices on cars, which are sold for, you got it, lower credit ratings, right? You pay less in interest because if you don't pay on time, they turn the car off. So these kinds of alternative solutions do come in, especially the ones around repossession and turning off. They do come in as harsher terms that drive lower interest rates. They absolutely do. Courts then immediately turn around and start finding those unconscionable and predatory, and we can have that conversation all day long. It's a business idea with legs. I just want to say, like in this particular area, the black letter law is pretty laid out, but it's a business idea with legs, if that makes sense. Yeah, great. And one that's really coming to the forefront right now with tokenization of assets. Like, so you have a cryptocurrency token that the car will turn on if you get near it, if you own that token, right? So that entire method for controlling assets now is kind of growing and growing. And yeah, the risk model is a huge part of that business. Okay, cool. Let's move on. to conditions. All right, y'all. Conditions. First of all, I do want to give you the sense that you're not insane. I know we're going to have to do some work on express and implied conditions. But did anybody read this and been like, wait, did we read this before? Did we read this before? Because the answer is yeah, we read all of this before. When did we read all about conditions before? We're just coming back to it in a completely different way of looking at it. Yeah. Yeah. In MPRO with the board approval clause, that's a condition. Remember we talked about the occurrence of a condition not fully within the control of the party, right? Where else? Now that we've located the area, express and implied warranties, right? We've got the same idea of a condition that triggers. Austin, go ahead. Ardente, tell me all about Ardente, yep.
That was for, there's like a contract for the sale of a home, and there were terms in there that were either conditions or a counteroffer.
Right, they were either a condition or a counteroffer. If it's a condition, and here's we got to bear down on, now we're going to understand conditions. And we got to go right back to where we started. We started contract formation with conditions. And so it's going to be very confusing unless you get them clear. If I feel like it, I will buy your car. What is if I feel like it? It makes it an illusory formation. Why? What is if I feel like it, I will buy your car? It's a free option. Absolutely, Mike. It's a free option because it's a condition entirely within your own control, which makes the formation illusory. Hey, what forms a contract? Day one. Offer, acceptance, consideration. What are the offer and acceptance? What form do they have to take?
If we're going common law, it has to be the mirror image.
Mirror image, yeah. A promise for a promise. This has to be a promise for a promise. A condition is not a promise. That is what I need you to see to start with. We started with what the hell's a promise at the beginning of the class. And to do that, we had to go to what's not a promise, which is conditions, and talk about that a lot. Now we're at the end of the class. We're going to talk about the conditions, and what we need to understand about them is they're not promises. Can you see that I will buy your car if I feel like it is not a promise? Can everybody feel that in their bones? That's not a promise? Okay. Remember our alternative to, which is still a condition. Remember our alternative to I'll buy your house if I feel like it. What was the standard example we used? That's the opposite of I'll buy your house if I feel like it. If it passes the termite inspection report. Okay. Now that is still underneath the I'll buy your house, is still underneath an enforceable promise, right? Still underneath an enforceable promise because it's the occurrence of a condition that's not fully within one party's control. But what's the, let me put it this way. Are you absolutely certain you're going to buy the house? You're not, Laura. Why?
Because the termite report could come back negative.
Yeah, because the termite report could come back negative. So what is if the termite report comes back positive, what's that? What is that?
That's the condition that if it's fulfilled,
then triggers the promise, right? And the way that courts tend to talk about conditions is the opposite of that, although it's equally true. It's the same thing. A condition is generally described as one, not a promise. Two, it is something that if it happens, excuses performance. We have contract formation, formalization, interpretation, remedies. Now we're getting into these cleanup questions, and the big cleanup question is conditions. These are terms under which we have a contract. Can you see it? I agree to buy your house if the termite inspection comes back good, which means if it comes back bad, the parties' performances are excused. We get out. It's an escape lever. And that's why we spent all that time in Empro, we spent all that time in Honorable Palmer, talking about whether one of the parties had put an escape hatch in there that they could use to just completely get out of the contract. We did that as a matter of contract formation, but it doesn't matter at this point. We're saying, look, even a fully formed contract, if the condition happens, the party's performance might be excused. Now, as is usually the case, think back to our discussion of interpretation. There are two big kinds of conditions. Condition one is going to be our express conditions, and that's what we're starting to look at here. Then there are going to be two big implied conditions. Just like our express warranties and our implied warranties. Remember that? Just like our express terms in our contract and our implied terms in the contract. Remember that? Now we've got express conditions and implied conditions. And the big express conditions, well, I can't tell you what the big express conditions are because they're just as wide as the number of conditions you can put into a contract. If the termite inspection report comes back, if Josh Fairfield's hair hasn't gone completely gray too late from like arguing about contract law, if, right, anything you want, if, then the parties get out of the deal, fine. That's your express condition. And all we got to talk about is their usual problems, okay, like, but what does it really mean? And is it a condition or is it actually a promise? Right? That's our fight there. Our other fight, just to preload it, is that there's a big condition that comes out of the ancient common law that we're going to have to really track. This is going to be like Hadley versus Baxendale level going back into the old law. And it's like this. Look, what happens if the other party is not performing first? Do you still have to perform? And at old common law, British common law, the answer to that was yep. If, for example, I pay you £100 for a carriage and you don't deliver the carriage, I have to pay you the £100 and then sue you for breach of contract. Like, you can see how that could feel sane for a minute. But as anybody who's like adjudicated playground fights, no, that's not how humans work at all. And so there's this implied condition. There's an implied condition that when performance is due before payment, a material uncured breach of that performance excuses the return breach of non-payment. That means it is a condition of every contract that there be no prior uncured material breach from the other side. It is an implied condition of the performance of every contract that there be no previous uncured material. And every word that has a case. We're going to go through previous, material, uncured. We go through every single one of those words and we'll have some discussions about them. But that's the black letter law there. That's for the restatement mostly, although it's also true of the Uniform Commercial Code. And then there's another big one in the Uniform Commercial Code, which is to say, we're going to let the parties out of contracts that they have made when aliens attack. These are called commercial impracticability clauses, which, by the way, sounds like something from the beginning of this damn course. What's it sound like from the beginning of this course? Impossibility. What's the other one? Force majeure. Well, that's what this is. It doesn't sound like it. That's absolutely what it is. Force majeure. Frustration of purpose. Right. So we've got impossibility and frustration of purpose. We talked about those in terms of looking at like what's a contract, right? But now we're coming back to them and saying, okay, it is get this, a condition of the performance, and this is true. It is a condition. First of all, anybody here not play Halo, not aware of Halo? Damn it. All right, well, in Halo, the Flood is like this alien species that's attacking everybody, and it's awful, right? Also then the Covenant, who's another group of aliens, attack Earth, and like everybody. So all the aliens are attacking. That's what you need to know. It is, in fact, this is true. It is, in fact, a condition of every contract that aliens not invade. It is, in fact, true that if aliens invade, almost every contract is like, off. Aliens invaded, we're not doing this. Right? Or, the zombie apocalypse, or like equal science fiction scenarios, I don't know, global pandemic, stuff like that. That litigation is ongoing. That stuff is still going on. Like, who could have seen a global pandemic given what we did? I don't know, everybody. Okay, so that's our two big implied categories. We've got our express categories, our big two implied categories. Any question on that? I just wanted to give you that framework so you could see where we're going. We'll do express first, then we'll do our two big implieds. Yeah, Larry.
Could you just repeat the first one for the implied, like when performance is due before payment?
Yeah, you bet. It is a condition of the performance of every contract in which performance is due before payment that there be no prior uncured material breach. Meaning, if their job is to deliver a TV to your door and they don't deliver, you don't got to pay. Now, payment can happen at any time, so payment generally is not considered to be a prior obligation. Usually, the performance that has to happen first is the performance, and that's usually done by saying when one party's performance can take a period of time, and the other party's performance can be done at once, then the performance that takes a period of time, that's considered the prior. And if there is a material breach that doesn't get cured while they're performing, then and they don't fix it, then the other side doesn't have to pay anymore. Any follow-up questions? I want to make sure you guys get this framework because stuff's about to get weird.
What, is that in the restatements?
Yes, that is in the restatement.
What section?
327, he says off the top of his head. Hang on. We'll see it when we get to Young. Hang on a second.
224 deals with conditions, I think.
Yeah, 224 deals with conditions. Yeah, it's gonna be around 224. Young. Let me just find Young here and see if it says it there. 229 is the response to that, disproportionate forfeiture. So yeah, it's 224 through 229 is the restatement. And to be clear, Jacobs and Young is the opposite of that, where it says if there's a minor enough breach, then we still make the other side pay, even though there's been a little defect. But if it's a material breach, nah. All right, cool. Nate, yep.
So does this apply like in the lawnmower example where the kid messes up the lawnmower?
Oh, absolutely.
So then that's why you use restitution as like a quasi-contract?
Yep.
Because there's no
Yep.
contract?
Yep, because there's no obligation to pay. That would be a material breach of the lawnmower contract. And because the performance of mowing the lawn takes a minute and payment doesn't take a minute, the performance has to come first. And because the performance was interrupted, there has been a material breach. Therefore, performance on the other side is excused. But that also means that half the lawn got mowed for free, which raises our natural ideas for unjust enrichment. What's nice about the end of the class, y'all, is I start to be able to speak pure lawyerese to you, and you're like, oh yeah, shit, this fits together. Like, hi, welcome, you have been transformed from humans into lawyers by this point. I have done incurable brain damage to you. But at least you understand sentences. Like people out there, they do not understand these sentences, so we're speaking a different language by this point in the class. It's nice. Certainly a relief to me. I like speaking human, that's not my deal. All right. So then back to Merritt Hill and express performances. Although we're coming up fast on our time, maybe I'll just ask Liam to set it up, and Graham, you'll take the other side of it, but then we'll continue this on next time. Go for it, Liam.
Okay, I'll try to go through it, the facts pretty quick. So, Merritt Hill was trying to buy a majority stock from Windy Heights, and the agreement included a $15,000 deposit, which they called liquidated damages if the sale didn't close, except there was a section titled conditions precedent, which included a requirement that Windy Heights get a satisfactory title insurance policy and confirmation from Farmers Home Administration. They didn't do that, and so Merritt said, well, we don't have to follow through with our agreement anymore, and also we want our money back from from you guys, and then Merit sued for the deposit and some consequential damages. The trial court rejected Merit's argument, appellate reversed it, and then in the end of the day, the court said that it is a condition. You guys just look at the language of the contract, like it says condition precedent, so therefore it's excused.
I mean, it couldn't possibly be simpler. Let's just get a little bit of black letter law in place, and then we'll talk about it for a couple minutes, and then we'll maybe start with Graham on the other side when we come back. But let's start with this. What's a promise, and where in the code do we see that?
Where in the code, I don't know. The promise is a manifestation of intent to act or refrain in a specific way. It's like 4, right, isn't it?
It's restatement 2, yeah. It's like, no, like full participation. It's like, you just go look and flip until you get it. It's like, as soon, why? Because that was the beginning of the class, right? Remember that? We were back there going, what the hell's a promise? Like, what's a promise for a promise? How does this even fit together? Absolutely right. So that's what a promise is, and what's a condition?
Condition, I mean, the language is, it hurts my brain a little bit, so I put it in different words, but an event which must occur before performance under a contract becomes due unless excused.
Right, and everything's done backwards here, but I like your phrasing better. Yeah. Right, it's an event, let me be clear. It's an event not certain to occur, right, that must occur before performance under a contract becomes due. Or another way of looking at it is, if it doesn't happen, then you get out of the contract. It's an escape valve in the contract, right? That's what a performance is. And one further dumb question, I was going to say, what's the dumbest top level reason the court's like, yeah, how do I tell between a condition and a promise?
Yeah, what the words say.
What the words say, and okay. So Graham, do you want to start with that teed up across the tape? Like, what do you think of that argument that this is a condition because it's under this section saying conditions precedent?
I would say, which side am I?
That's a great question. Which side do you want? Do you want this as a condition or a promise?
I'll take this as a condition.
Okay, you'll take this as a condition, which is what the court, in fact, says on this daft argument that, like, it says condition precedent. That means it's a condition, right?
I would say then it's a promise because it's reasonable to believe that a party agrees to it in the contract, that they are intending to fulfill what
right. If Windy Heights says we're gonna go get this report, the question is, are they promising to go get that report? What's your argument that they're not promising to get that report?
Well, they have an out in the contract, like they don't have to, but then by the contract, we also get an out.
Okay, I like that he keeps using the word contract because that means you're gonna like commit a murder in broad daylight. What's the problem with, so like this is a rough one and you're probably fighting the losing side here and he's absolutely right, but what's the problem with calling this a contract if that's true, if this is a condition? It's wildly elusive. What contract, Your Honor? They want to have their cake and eat it too. Among other things, in this litigation, Your Honor, they too are asking for damages. Damages, we might wonder, for what? Not breach of contract, not on this theory, right? If it's not a promise to do it, if it's a pure condition, and if that condition is entirely within the control of one of the parties to the contract, we're right back to where we were in the first week of class. This contract's entirely illusory. We're right there back with Empro and Palmer and the rest of the, and Sun Printing and Cardozo. Okay? That's what I want you to see. I want you to take that away. We're going to develop this a little bit more, and we'll sort of start with you saying, okay, let's back up. This is a breach of contract action. There's no way this is a condition. That's where we'll begin next time.